the appeals, Patel, Anwar and Allen, Secretary of State for the Home Department.
Lord Carnworth will give the judgment of the court.
These linked appeals raise somewhat technical but nonetheless important issues about the respective duties of the Secretary of State and the first-tier tribunal on an immigration appeal under the so-called one-stop procedure under Section 120 of the Nationality, Immigration and Asylum Act 2002. The Patels had entered in March 2009 with leave to remain for 2 years. In February 2011, they applied for further leave, relying on Article 8 of the Convention of Human Rights. Their application was refused by the Secretary of State, but without making a decision to remove them at that time. Relying on Court of Appeal authority, they claimed that the failure to make a removal decision rendered the decision to refuse leave unlawful. Mr. Alam, a Bangladeshi citizen, entered the UK on 26 August 2007 as a Tier 4 student with leave to remain until April 2011. He applied for leave to remain to continue his studies, but the Secretary of State refused his application on the basis that he had not produced the required bank statements showing the necessary level of funds in the month before the application. Although he produced the appropriate bank statements at the tribunal hearing, they were excluded under Section 85A of the 2002 Act, which limits generally evidence of the tribunal to that submitted at the time of the decision. Mr. Anwar, a Pakistani citizen, also entered with leave to remain as a student and applied for his leave to be extended to enable him to complete his course. In this case, his application failed because the confirmation of acceptance for studies failed to include a document referred to in it. Again, he attempted to make good the error at the tribunal, but again his appeal failed. The Supreme Court unanimously dismisses all three appeals. In the Patel case, the court holds that the Secretary of State was under no duty to issue removal directions at the time of the decision to refuse leave to remain, and that the actual decision was not invalidated by her failure to do so. To the extent that Court of Appeal decisions suggest otherwise, they were wrong. The Alam and Anwar appeals raise the issue of whether the statements and evidence filed by Mr. Alam and Mr. Anwar to the first-tier tribunal amounted to, quotes, additional grounds under Section 120 of the 2002 Act, which the first-tier tribunal was obliged to consider as part of a human rights case, notwithstanding the bar in Section 85A. The court holds, agreeing with the majority in AS Afghanistan with the Secretary of State, that Section 85(2) of the 2002 Act imposes a duty on the tribunal to consider any potential ground of appeal raised in response to a Section 120 notice, even if it does not directly relate to the issues considered by the Secretary of State in the original decision. However, on the facts of these cases, that was of no assistance. Mr. Alam's case on human rights grounds was considered but failed before the upper tribunal because there was insufficient evidence of a private life in this country apart from the time he had spent as a student under the rules. There was no error in the upper tribunal's approach. In Mr. Anwar's case, no separate human rights grounds were advanced on his behalf either before either tribunal, and so the issue as to whether the tribunal would have been obliged to consider them, and if so, to what effect, does not arise.
Court is adjourned.